Oui, je m'excuse.
Apologies to the witness. The sound in the room is much too loud, and it's so loud that I can't hear interpretation. I'm at the maximum volume on my earpiece, and I can't hear the interpreter. Apologies.
Oui. Mr. Ward, if you can just...
Monsieur le Président, ce genre de test...
Chair, this kind of test should be done before the start of the meeting. I think that it would be easy to do so before we start with the witnesses. I hate having to interrupt. I thought that the sound had been tested and it was fine, but for some reason, we don't test the room sound before the meeting.
Give me a count to 5 to make sure that everything's okay. Go ahead, sir.
1, 2, 3, 4, 5.
Wait, c'est plus mieux, je pense. Okay, thank you, Mr. Ward. Please go ahead, up to 5 minutes to address the committee. Thank you, sir.
Thank you. So my name is Jason Ward, Principal Analyst of CICTAR, the Center for International Corporate Tax Accountability and Research. Thank you very much for inviting me to testify. I come to you from the unceded lands of the Darug people, more commonly referred to as the Blue Mountains outside of Sydney, Australia. So I'll begin with some brief opening remarks. I'm not an expert in Canada's Conflict of Interest Act, but I do have significant expertise in the abuse of tax havens and trusts. CICTAR has done some relevant work in relation to tax avoidance by Brookfield, and this mostly occurred during the period when now Prime Minister Mark Carney was chair of Brookfield. In the lead up to the federal election in Canada and following the election, our research on Brookfield has received renewed interest in Canada and globally. In addition to Brookfield, we've also done numerous reports and some unpublished research related to tax avoidance and the use of tax havens by several of Canada's largest public pension funds. So I'll review some of the relevant research very quickly and then conclude with some simple recommendations for greater transparency in Canada. So our first research relevant was done in January 2021, and we published a report in English entitled Tax Dodging by a Canadian Crown Corporation, Rivera Living Making a Killing. That looked at PSP, the public sector pensions 100% ownership of Rivera. And due to the incomplete reporting and the lack of available public information, we examined Rivera's ownership of care homes in the United Kingdom and found significant use of tax havens and tax avoidance on the ownership of those assets. We published a similar report in February 2021, which was facing the UK rather than facing Canada. And that report was called Darkness at Sunrise, UK Care Homes Shifting Profits Offshore. In February 2022, we published a report in both English and French on Orpea. It's now renamed EMIS after a major scandal and a collapse. Orpea is the largest care home company in Europe, and CPPIB, the Canadian Public Pension Investment Board, was the largest shareholder for over a decade. The English version of that report was entitled Caring for People or Profit, the Financial Engineering of Real Estate Investment of Group Orpea. And then on the same topic, but for a Canadian audience, and focused on CPPIB's failure of governance and loss of 500 million Canadian dollars in workers' retirement savings. In October 2024, we published another report in both English and French. The English version was entitled CPPIB's Orpea debacle. Orpea was using undisclosed Luxembourg subsidiaries to shift profits away from shareholders, including CPPIB, into the pockets of management who actually served some jail time in France. And the company was eventually bailed out by the French government. Our first report on Brookfield was published in June 2023, called Brookfield's Bermuda Base is Canada's largest alternative asset manager dodging global tax. And it looked at previous research on Brookfield from Canada and also 4 international case studies to identify the use of tax havens and tax avoidance by Brookfield in multiple countries. In February 2024, we published a report in Norway entitled Kindergarten Landlord, Should Norwegian Taxpayers Finance Profits for One of the World's Largest Asset Managers? And that report examined Brookfield's investment in Norwegian kindergarten real estate and the impacts of public funding on that. In May 2024, we published a report in Colombia called Brookfield's ETHI, a case study on the need for change in the global tax system. This report examined Brookfield's profit shifting via Bermuda from its investment in Colombia's largest hydropower electricity generator, which had been privatized previously. And most recently, in September 2025, we published a report on Brookfield's tax avoidance on privatized water and sanitation services in Brazil. The English version of the report was called Water Down Investment, Top-Up Returns, The Pitfalls of Financing Basic Sanitation in Brazil. That primarily looked at the abuse of public subsidies that Brookfield has taken advantage of to avoid tax payments in Brazil. We've also made a detailed submission recently made public to the New South Wales Parliament inquiry on Brookfield's failed ownership of Healthscope, the second largest private hospital company in Australia. The company is now in administration, and its troubled hospital in New South Wales has just been returned to public ownership. It's also worth noting that Caisse de Dépôt Quebec, CDPQ, was also a significant investor in this hospital company. Our submission examines Brookfield's extensive tax dodging and use of tax havens on the Healthscope investment and a range of other investments.
Yeah, sorry, we're over time quite a bit. So I'm gonna have you wrap up right there. There may be some questions that come your way that you can circle back to what you were going to say, and I'm going to start those lines of question with Mr. Barrett from the Conservative Party of Canada for 6 minutes. Go ahead, Mr. Barrett.
Your report details how Brookfield uses subsidiaries in low tax jurisdictions like Bermuda and related party debt arrangements to reduce taxable profits. Could similar opaque corporate mechanisms be used by public office holders or their associates to shield ownership or economic benefit in ways that undermine the spirit of Canada's Conflict of Interest Act?
Absolutely. The use of subsidiaries in tax havens, the use of trust structures can both shield public office holders from from having their income taxed as it was intended to be in Canada.
You wrote that Brookfield provides only the and I think it's a direct quote, bare minimum, end quote, of disclosure despite its ESG branding. So given that the former Brookfield chair, Prime Minister Mark Carney, has built a public reputation around transparency and responsible capitalism, what minimum disclosure standards should apply to public office holders to prevent hidden offshore holdings?
Well, I think the use of blind trust is not an appropriate method for dealing with that issue. And I think investments in assets should be fully disclosed for any public office holder to make sure that they are living up to the spirit of the law and paying tax along with other ordinary Canadian citizens who, in general, I assume their income is taxed from their payroll deductions, and there's less ability to use offshore bank accounts and advice from high-powered accountants and tax lawyers in order to avoid their obligations to fund domestic services in Canada.
So that's interesting that you've said effectively that blind trusts don't work in this case for the purposes of the Conflict of Interest Act. So given that, what specifically would you suggest replace them? For example, we've had witnesses who have supported the notion that divestment, which currently in the Act is either placing controlled assets in a blind trust or their liquidation, to only allow for assets to be sold and then for the proceeds to be placed into trust and then managed by a portfolio manager. Would that type of solution satisfy the lack of transparency or the ability to hide the details that you've suggested that it might?
Yes, I do think that approach deals with the issue. If you're liquidating the assets and then putting the proceeds into a blind trust, I think that sufficiently covers the problem there.
So the report highlights cases like Canary Wharf in the United Kingdom, where Brookfield generated significant revenue but paid very little local tax. What lessons are there for Canada in terms of tracking the true location of economic activity and profits?
Yes, firstly, on the Canary Wharf investment, the UK tax authority has since investigated further and required that investment to pay money. I think that the setup of that investment was largely to avoid future payments of capital gains on the investment rather than the ongoing rental income from the Canary Wharf property. In terms of what Canada should do, I think it's very much overdue for Canada to adopt a public country-by-country reporting regime. So Australia has just done this, and that is going into effect this coming year. The European Union has also done this, and that is coming into effect this next year as well. Australia's version is significantly stronger, and this requires, in the case of Australia, any multinational that operates here with over 10 million in revenue is required to disclose all of its basic financial details, profits, losses, revenue, related party revenue, number of workers in a list of 40 jurisdictions that are widely regarded as tax havens. So this would include places like Bermuda, Singapore, Cayman Islands, along with Switzerland, Singapore, Hong Kong, and many other jurisdictions that are commonly abused as tax havens. It's hard to fix a problem if you can't see it, and I think transparency is ultimately the first step, and we would strongly encourage Canada to follow suit of both Australia and the European Union in requiring disclosure for all multinationals.
5 seconds.
Just very quickly, would banning the use of tax havens by public office holders allow for more transparency for Canadians?
Quick response, please.
Yes, I think that would be an interesting idea to pursue.
Thank you, Mr. Ward. Thank you, Mr. Barrett. La prochaine intervention est pour Madame Lapointe. Et je pense aussi, Monsieur Ward, que Madame Lapointe...
And I think that Ms. Lapointe will be asking her question in French.
Oui. Commencez, Madame Lapointe, pour 6 minutes.
Ms. Lapointe, you have 5 minutes. Thank you, Chair. Hello, Mr. Ward. It's interesting to see you from Sydney, and welcome to the House of Commons here in Ottawa. With Mr. Barrett, you mentioned a public declaration by country. How would that improve the public's trust towards the Canadian tax system?
That is a fantastic question. I think that the faith in the Canadian tax system is undermined when it becomes clear to the general public that some of the richest individuals and largest corporations are not paying their fair share and are avoiding taxes. So I think that having the information out in the public and requiring multinationals who are clearly dodging hundreds of millions of dollars in Canadian taxes disclose where they're shifting their profits to allows the parliament and legislators to actually see what's going on and address the problem. This information is currently available only to OECD tax authorities. So the Canada Revenue Agency gets this information, but it can't be used by people like yourselves in order to decide, in order to understand what is going on and what loopholes need to be closed in order to stop companies like Brookfield from shifting profits to Bermuda, the Cayman Islands, Luxembourg, and other such jurisdictions.
Merci. Pour faire suite.
Thank you. Just to follow up on what you just said, can you give any examples of OECD countries or from the European Union where that type of disclosure increases compliance?
Yes, so in the European Union, there has been public country-by-country reporting on financial institutions for a decade now, and studies have shown that the European banks have reduced their usage of subsidiaries in tax havens and have in fact increased the amount of tax paid by, I think it's an estimated 10% from what was there prior to that disclosure requirement. And there are about 150 companies around the world who do voluntary public country-by-country reporting now, following the Global Reporting Initiative, or GRI, tax standard, which was the Australian legislation is based around that. And it is the first widely recognized standard for public country-by-country reporting, and it builds upon what the OECD does already in terms of a confidential country-by-country reporting.
Merci. Vous avez parlé de l'Australie.
Thank you. You mentioned Australia and Europe. Is it all countries in the European Union that you're alluding to?
Yes, the public country-by-country reporting was a European Union directive that has now been introduced into national law across all EU jurisdictions. So it is, and actually Romania is the first country that implemented ahead of the pack. And so there is disclosure already available in Romania, and disclosure from other European Union countries will be coming in. The problem with the European Union setup is that it only requires disclosure on EU member states. And so the taxes paid, income, related party transactions within the European Union, and does not cover tax havens outside of the European Union. Of course, there are tax havens inside the European Union, like Ireland, Luxembourg, and the Netherlands, but it's limited in its geographical scope to the European Union. Whereas in Australia, it's a broader geographic scope and covers what are widely recognized as the most abused tax havens.
Merci. Quel secteur ou type de...
Thank you. Which sectors or companies represent a large risk of tax avoidance in Canada?
Yes, a good question. I would say that the top two sectors in terms of aggressive tax avoidance are the large IT firms. I'll give you one example. I mean, Microsoft is facing the largest tax bill in global history. The U.S. Internal Revenue Service, IRS, is pursuing Microsoft for some close to $30 billion. And that may be just the tip of the iceberg, because the case that they're pursuing in the courts is for a limited period of time, but would cover a larger period. The other sector that is highly tax aggressive is the big pharma, and it's incredibly easy for both IT and pharma to shift their intellectual property into countries or into structures where it's easy to avoid tax because of royalty payments on intellectual property going into structures that provide tax shelters. So even countries that are not necessarily full-fledged tax havens have created structures that allow discounted tax rates. So it's called patent box regimes. So just on Big Pharma, the 6 largest US pharma companies have actually paid negative tax in the United States over the last 2 years. And it's very clear that the vast majority of their income and profits are generated in the United States, but they're reporting that income in offshore jurisdictions and actually have received refunds collectively over the last 2 years.
Okay, thank you, Mr. Ward.
Merci.
Merci, Madame Lapointe.
Thank you, Ms. Lapointe.
Mr. Ward, that Ms. Lapointe was from the Liberal Party of Canada. La prochaine intervention est pour M. Thériault de la Bloc.
Next intervention is for Mr. Thériault from the Bloc Québécois. Mr. Thériault, you have 6 minutes. Thank you, Chair. Thank you very much for your testimony, Mr. Ward. You spoke quickly. It was very impressive, and you gave our interpreter a lot of work. I'll try to speak a little bit more slowly. From the start of our study, since the start of our study, I've been asking 2 more theoretical questions. I don't have the same expertise as you, but I do have a similar expertise, and so I'm hoping that both of our expertises will be able to converge. Do you believe that tax avoidance, even though it's legal, is it moral?
A fantastic question, and I will try to slow my speech, but I do not think it's moral. I think that people have an obligation to contribute to the society and the public services, and I think even though it may technically be legal, the problem is that much of this law was written by corporate lobbyists and is not to the benefit of society. I do think that there's significant need for greater transparency and reforms to close loopholes that were written into the law for the benefit of wealthy individuals and large multinational corporations who have undue influence over the tax system. And I think that, there's one important development to make here. I think that with the Trump administration in the United States, the ability to progress through multilateral processes has been severely gutted. But I do think that there's an emerging opportunity through the United Nations Tax Convention that is being developed now in order to really take a fundamental look at how the global tax system has been misshapen for the benefit of a few and to the detriment of the people and the planet. And I think that there's some golden and urgent opportunities for reform. And I think that there's also opportunities for Canada to take a leading role in pushing forward for greater transparency.
Before I move on to my next question, you quoted a series of studies earlier. I know that we could look into those, but I was wondering if you would be able to share these documents with us so that they could be objective elements to be included in our report. If you could share them with the clerk, that would be appreciated. I see you nodding, so thank you. Now, it's not because something is legal that it is moral. And another principle that I've been focusing on is that ethics requires more than law and legislation. A code of conduct must have a larger scope. Now, following what you've said on Brookfield, I'm even more concerned than I was at the start of our study. From the beginning, I've said that we're in a never-before-seen situation. We have a person that used to lead this company who is now Prime Minister. And we have few tools because of our legislation in order to frame an appearance of a conflict of interest or a real conflict of interest. We limit a conflict of interest to an individual's impact. But if we're talking about a general impact, well, people in the ethics commissioner seem to say that it's not a problem, whereas there can be a conflict of interest. Brookfield could be making a lot of money, even if the prime minister has a blind trust. He might not know how much his fortune is increasing, but he can still benefit Brookfield's assets. So we're dealing with a case where things aren't necessarily transparent and clear regarding morality. I'm going to stop there, and I would like to know what you think of what I've just said.
Yes, I completely agree. First of all, I have supplied links to the documents that I referenced to the clerk, so hopefully those will be shared with you. And I do think that it's incredibly important for a leader to set a moral standard, and that it's highly problematic that the company that he was chair of for many, many years was engaged in very highly aggressive tax avoidance and continues to be, and is also investing in international assets that are privatizing infrastructure, not delivering services to the people as was intended, and taking advantage of generous tax concessions that should be, in the case of Brazil, allowing more people to have access to basic sanitation rather than lining investors' pockets from the proceeds that are partly derived from public subsidies going to this industry. I think that there's serious moral questions about that present major problems on the tax front, and also on how profits are extracted in a private equity model that is all about short-term gains, and leaving aside the question of societal impacts.
Monsieur Thériault, et comme
Monsieur Thériault, as Mr. Ward stated, we do have the links to the documents. I spoke to the clerk. We will be translating the documents. So we will be translating all of that, and we will share it with the committee members.
Cooper, you are next from the Conservative Party. 5 minutes, sir. Go ahead, please.
Mr. Ward, Brookfield owns substantial investments in Canada and is the largest owner of commercial properties in major cities across Canada, correct?
That's correct, yes.
Okay. And would it be fair to say that Brookfield has reaped very large profits from its investments in Canada?
That would be correct, although
okay, just in terms and while Brookfield has reaped large profits in Canada, it has paid relatively little in the way of Canadian taxes, correct?
Correct.
And help me understand how Brookfield avoids paying taxes in Canada. As I understand it, Brookfield sets up a complex web of foreign subsidiaries in which investment funds ultimately end up in Bermuda, the Cayman Islands, and other tax havens, correct?
Correct.
Okay, and that's precisely what Mark Carney did when he was the chair of Brookfield, when he set up the $10 billion or $15 billion Global Transition Fund. He registered it in Bermuda. The $10 billion second Global Transition Fund, he registered it in Bermuda. And the $5 billion Catalytic Transition Fund, where he registered it in the Cayman Islands.
What's the point of order?
Do I have that right?
Hang on, Mr. Cooper. Point of order, Ms. Church, go ahead.
Mr. Chair, I'm just wondering if we can ask yourself as the chair to please illuminate how this line of questioning is relevant to the study of this committee, which pertains to a review of the Conflict of Interest Act, and not about either the tax dealings of any particular individual or of tax law, frankly, generally.
Okay, so I've been chairing this committee for almost 3 years now. I generally give a lot of latitude, as we do in the House, for members of the committee to use their time. And I do expect Mr. Cooper, as a seasoned member of this committee, that he will come back and bring this back to where it needs to go. And I would give as much latitude to you, Ms. Church, as I'm giving to Mr. Barrett, or Mr. Cooper right now. On the same point of order, Mr. Barrett, I've stopped the time too, by the way. Go ahead, Mr. Barrett. I don't want to engage in debate on this.
No, but it was about whether this pertains to the motion. I'm not sure, Chair, if perhaps you could read the motion or have Ms. Church read the motion back into the record. Tax havens is specifically spelled out. Carried interest payments, this is very relevant to the application of the Conflict of Interest Act. And so it's the line of questioning it's very clear to see where it's leading, but it also speaks directly to the motion. So I appreciate your ruling with respect to latitude, but I don't think respectfully that any latitude is required. Mr. Cooper is engaged in a line of questioning that goes to the heart of the matter that we're studying, and that's why we have this expert.
I appreciate that intervention, Mr. Barrett. I'm not going to reread the motion. I think all the members are clear of where this is going. We are studying the Conflict of Interest Act as it relates to designated public office holders, and perhaps the recommendations will come in the response. The recommendations of the committee and the report will come from some of the responses that Mr. Ward gives to Mr. Cooper's questions. Mr. Cooper, you have 3 minutes and 49 seconds to continue your questioning. Go ahead.
So to the witness, did I get that right with respect to Mark Carney setting up 3 major multi-billion-dollar clean energy funds from Brookfield in tax havens, including Bermuda and the Cayman Islands?
I can't speak to the specifics of those particular funds, but it would seem par for the course.
Okay, thank you very much. On page 12 of your report, there is reference to Brookfield's tax gap over the last 5 years between 2017 and 2021. Just so that I'm clear on what a tax gap means, it is measuring the difference between taxes actually paid and taxes that would have been paid if the statutory Canadian tax rate had been applied to profits reaped. Do I have that right?
That is correct.
Okay. And according to your analysis, or the analysis cited in your report, Brookfield's tax gap in just 5 years between 2017 to 2021 was over $6.5 billion. Is that right?
That's correct, and that was based on research done by the Canadians for Tax Fairness and by some analysis from the Toronto Star as well.
So it would be fair to say that the extent of Brookfield's tax avoidance, taxes that it should have otherwise paid in Canada in just 5 years, was over $6.5 billion.
Yes, I mean, the tax gap is looking at the statutory rate, and there are some reasons why legitimate reasons why companies pay below that, but that's an indication of a major underpayment of taxes that, in the spirit of the law, should have been paid in Canada to finance public services in Canada.
Yeah, I'd say $6.5 billion is a lot of money. Would it be fair to say that Brookfield is Canada's largest tax dodger amongst corporations?
It has been labeled as such, and if it's not the largest, it's clearly in the very top tier.
Well, your report cites 123 of Canada's largest corporations, and it found that the largest tax gap for 2017 to 21 was none other than Brookfield, right?
Correct.
Thank you, Mr. Chair.
You still have a minute, Mr. Cooper. If you're,
Okay, well, I would just ask the witness if he can just elaborate on why it is in his submissions that a blind trust is not an appropriate mechanism.
in 45 seconds, sir.
Well, I think because there's still the ability to profit from something in a blind trust, even if you don't know the details of what's going on, you're benefiting from the actions that might be taken by somebody else on your behalf.
Okay, thank you, Mr. Cooper and Mr. Ward. Next, we're going to go to Ms. Church from the Liberal Party for 5 minutes. Go ahead.
Oh, she's going to cry.
Thank you, Mr. Chair. Mr. Ward, so you started off your remarks by saying that you're not an expert on Canada's Conflict of Interest Act. Is that correct?
Oh, here we go.
Correct.
Do you know who is covered by Canada's Conflict of Interest Act?
I'm assuming that it relates to public officials, but I have not read the act. I am an expert on tax havens and other using various schemes to avoid tax.
So you would agree then that it doesn't cover corporations, that it's not the intent of the act? The intent of the act is to cover public office holders?
I do not have the knowledge to respond to that adequately.
Well, let's talk about blind trusts then, if you're not familiar with the act itself. Are you aware that investments that are entered into a blind trust are fully disclosed before they're put into a blind?
What the hell?
Expert on tax havens and other using various schemes to avoid tax.
So you would agree then that it doesn't cover corporations, that it's not the intent of the act? The intent of the act is to cover public office holders?
I do not have the knowledge to respond to that adequately.
Well, let's talk about blind trusts then, if you're not familiar with the act itself. Are you aware that investments that are entered into a blind trust are fully disclosed before they're put into a blind trust by a public office holder?
That the investments are disclosed before entering into a blind trust?
Correct.
Yes.
So those, just for the sake of transparency, those assets then are known, the public office holder then puts them into a blind trust so that from that point forward, they no longer have control over those assets. Correct?
Right.
That's right. So a public office holder then would have no awareness over the performance or even the composition of the assets that were in a blind trust once that trust is established, correct?
Yes, but they would benefit from actions taken by others on their behalf in profits that might be derived into that.
How would they know
trust.
that if they didn't know what the composition of the blind trust was?
Well, I think there's an example here that is very relevant south of Canada with the situation of the Trump administration profiting from deals that are being constructed by his children. That's not a blind trust situation.
But you understand the actual responsibilities of the trustee of a blind trust, which is that they have the authority, fiduciary authority over the trust and the assets in that trust to make changes to it, to sell those assets, that a person who establishes a trust actually is prevented under Canadian conflict of interest legislation from providing direction to the trustee. So the public office holder who establishes the trust actually does not have control, has not provided any guidance to the trustee, and has no awareness as to the composition of that trust following its establishment. You're aware of that in the Canadian context?
I'm aware of that in the Canadian context. However, if you look at the case of big four accounting firms who also have created legal situations where information is not supposed to transfer from one part of the business to another, it has. And so I do
Mr. Ward,
think
what
that
relevance does that have to the Canadian Conflict of Interest Act that covers public office holders in the Canadian Parliament?
it's a parallel situation in which rules that exist are abused because there's information transferred.
Is there an ethics
between
commissioner
trustees.
that is governing private sector blind trusts or whatever situation it is you're talking about in big accounting firms? Is there a publicly funded, determined ethics commissioner in office responsible for oversight in those cases?
In some jurisdictions, yes.
In Canada?
I'm not familiar with the Canadian law.
No, there is not. There is no public ethics commissioner that oversees those. That is a role of Parliament. When a public officer has a blind trust, is that public office holder shielded from tax for any gains or losses that may be incurred of the assets in that trust?
Well, it depends on how the investments in the blind trust are structured, doesn't it?
Well, I think the answer there is no, that tax law actually applies to the assets that are controlled by a blind trust, and it is the fiduciary, the trustee in this case, that is actually responsible for the tax management of those assets. Is that not correct?
There are huge amounts of loopholes, which we've just been discussing, that are in the tax law that allow individuals and corporations to significantly reduce their tax obligations under legal provisions in the law that we've just been discussing.
Now, Mr. Ward,
clearly,
I'm
in my
sure that
view,
you can help me
immoral.
distinguish between what is general tax law or international tax law and what I'm asking you, which is for an individual that has assets in a blind trust, those assets are subject to tax law, yes or no?
Of course they are subject to tax law.
Of course they are subject to tax law.
But is the tax law an effective mechanism in order for them to pay the appropriate amount of tax?
But Mr. Ward, I don't want to seem too disagreeable with you, but I guess I'm trying to draw a distinction between the case of an individual public office holder, a parliamentarian who puts their assets in a blind trust for the purpose of.
I'm going to have to get a wrap up.
Okay,
Quick
for the purposes of being able to represent public office, different from any concerns that an individual like yourself may have about tax law generally, which we can all as parliamentarians accept is worthy of debate, but is a completely separate situation from what we're talking about here.
We're 40 seconds over. I'm going to give you 10 seconds to respond, Mr. Ward, please. Thank you.
I think there's a moral obligation to show leadership in avoiding conflicts of interest or potential conflicts of interest and being clear.
Thank you, Mr. Ward. Thank you, Ms. Church. We were a minute over on that one. So, Monsieur Thériault, pour 5 minutes, s'il vous plaît. Commencez.
Mr. Thériault, you have 5 minutes. Thank you, Chair. We need to review the conflict of interest legislation. And my opinion is very different from Ms. Church. We know that her leader, and we're talking about tax avoidance with her leader and tax havens, but indirectly we're looking into the legislation and we want to know whether or not the Conflict of Interest Act is sufficient to ensure that Canadians can trust its institutions. That's the main goal. And the legislation itself, and this is supported by the Ethics Commissioner, is that we shouldn't be too coercive in reviewing the legislation in order to attract people from the private sector to become public office holders because we need their knowledge. That's what the Ethics Commissioner said. I think that a Prime Minister needs to lead by example and requires the highest level of transparency. Do you agree with that statement?
I firmly agree with that statement, that there's a moral obligation to set a very high standard.
Or, on a présentement quelqu'un qui était dirigeant.
So now we have somebody who used to be at the head of a company that is not transparent. Do you agree with that statement as well?
I agree with that statement.
OK. Donc, il faudrait faire.
So, we'd have to trust this person who formerly led a company that is not at all transparent, that has been abusing the system and doing a lot of tax avoidance, and now we're supposed to believe that we should be reassured by the Prime Minister putting his assets in a blind trust and that the legislation is sufficient for people to trust their democratic institutions. With your expertise and with your knowledge, do you believe that that's enough, as stated Ms. Church?
I think that there's a serious credibility problem, and I've heard comments from Prime Minister Carney in response to allegations of tax avoidance that really have not gotten to the core of the moral issues involved, in that there is an obligation to contribute to funding like ordinary Canadians in order to have the public services that everybody wants and desires, and in fact that businesses need in order to thrive in Canada. The public funding of infrastructure is absolutely essential for businesses big and small across Canada. And I think it's a problem when the Prime Minister has led a company that is seriously engaged in aggressive tax avoidance in Canada and on its investments around the world.
Je reviens sur ma question tout à l'heure parce que c'est ce qui...
I'm going to come back to my question that I asked earlier because it's something that's been on my mind. This is not a minister that we're talking about. Even if one can recuse oneself, we're not talking about a minister or a member of parliament. This is the Prime Minister. That he makes decisions that have an impact on the economy. And there's a bill now for rebuilding Canada, rebuilding the Canadian economy, and these are all fields in which Brookfield has interests. And so does it not seem that we should perhaps be concerned and perhaps seek to better frame all of this? We don't want people to believe that there might be a conflict of interest.
Absolutely. And I think that the example that I began to speak about in Australia of Brookfield and the Caisse de dépôt Quebec, CDPQ, investing in a private healthcare, private hospital company in Australia is a lesson for Canadians that be careful in terms of private investment in infrastructure and public services, because it often leads to a situation where there's profit extraction that harms tax payments that should be made, and also generally is not contributing to a better service, a better society, and the public services that people need. So I'm all in favor of robust and strong investments by funds in Canada to improve infrastructure, to improve services, but I think that has to be done carefully and with care and with a great amount of transparency and accountability and public oversight to ensure that benefits are widely received and not lining the pockets of particular investors, Brookfield included.
Okay. Merci. C'est plus que 5 minutes.
That was a bit more than 5 minutes. Mr. Hardy, you have 5 minutes. Thank you very much, Chair. Thank you, Mr. Ward, for being with us today. I am a young MP here, and I only started recently. I've noticed that our legislation has been built to be used by those in power. Often, people say that they have the right to do something. Do you agree with that statement?
So I believe that lots of the legislation has been written by corporate interests and is abused by corporate interests for their own personal, private gain.
Et ça, ben, si je vous écoute, effectivement.
And I think that Canadians are starting to lose trust in our institutions, and this kind of behavior only reinforces that lack of trust because they're hearing politicians or leaders say that they have the right to do something, it's legal. So do you agree with that?
I completely agree. I think that there's an undermining in the faith of public institutions when wealthy individuals and large corporates kind of play by their own set of rules that they in fact written, whereas ordinary citizens are held to a very different standard and don't have the legal quote unquote rights to hire an accounting firm, to set up a Swiss bank account and do other things that are available to wealthy individuals and the largest multinationals in the world.
On revient à Brookfield présentement.
We're talking about Brookfield right now, and we saw that you stated that Brookfield is one of the biggest companies in Canada with a tax rate under 5% for over 15 years. So that's billions of dollars in revenue that was not sent, in taxes that wasn't sent to Canada. So does that mean that Canada's system is too lax?
I do think that the Canada system needs to be tightened, and companies like Brookfield shouldn't be able to get away with whether it's legal or not. there should not be available to have such low tax payments in Canada for such a sustained period of time. I think that's a clear indication that there's a problem in Canada's tax system as well as in the global tax system that need to be addressed and fixed. And I think transparency is the first step, and transparency can then drive both public opinion and political reform.
Donc, vous allez voir où est-ce que je m'en vais avec ça. Donc, on a
So
une
you might be seeing where I'm getting at. So there's somebody who was at the head of a Canadian company that was doing everything that he could to avoid paying taxes in Canada that would benefit Canadians, and that person has become prime minister of a country. Do you believe that, given the role of the prime minister, they should be doing everything that they can to ensure that multinationals and big companies that make billions of dollars should give back to Canadians? Do you believe that the Prime Minister of Canada should do this? Or do you believe that he won't move forward on the process towards transparency?
Well, I think there's a golden opportunity for Prime Minister Mark Carney to change colors and really show that he can take leadership and he can move legislation to increase transparency for multinational corporations and make the largest, wealthiest companies in the world pay their fair share of tax in Canada and around the world. There is an ability to change ways and to show leadership, and I think that would go a long way to restoring faith in the Prime Minister and in the system in Canada.
Dans le fond, ce que je comprends, c'est que, comme vous dites, il y a un rôle de...
So there's a leadership role here, and Canada could be in a position where someone with a lot of knowledge in economy and from the private sector could send out a clear message for countries throughout the world and say, listen, businesses who are making money in this country should participate in the economy of that country. Do you believe that that should be part of the role as Prime Minister?
Absolutely. And I'll add to that I think that Canada's backing down on the digital service tax in the face of threats from the Trump administration was a grave mistake. You cannot negotiate with a bully. And so I think I would strongly encourage Canada and other countries to move forward with the digital service tax in the absence of any possibility of moving forward at the OECD in terms of reforms that were moving there. And I think it was a grave mistake for the G7 meeting in Canada to allow U.S. companies to avoid the global minimum tax as well. This is undermining the progress that has been made through multilateral negotiations over many, many years. And Prime Minister Carney was the host of the G7 meeting that permitted U.S. multinationals, the most aggressive tax dodging companies in the world, some of the largest companies, to continue to be outside of a global minimum tax system. So I think that there's huge opportunity to shows leadership, and that Canada can play a leading role in driving both domestic and international reforms to create a fairer system where we have adequate funding for public services and infrastructure that everybody wants and needs.
Okay, merci, Monsieur Hardy. We're going to go to Mr. Saini from the Liberal Party. He's going to be sharing his time with Mr. Saray. Mr. Saini, 5 minutes. Go ahead, sir.
Thank you. Mr. Ward, I'm disappointed the way you have been coming along. You've been invited to deal with conflict of interest, and the only subject you seem to pick is Prime Minister Carney and Brookfield. That was not your mandate, and you had no duty to tell what the Prime Minister of Canada should be doing. He is the Prime Minister chosen by the people of Canada just recently, and people had confidence in him to be elected to that power.
Is there a question?
I was not provided, I was invited to testify as an expert on the subject of tax havens. As I said in my opening remarks, I am not an expert in Canada's conflict of interest law, and I'm hoping that my knowledge of tax havens and tax avoidance is of benefit to the deliberations of the committee.
Mr. Ward, if you are not known what the conflict of interest are, then you shouldn't be interfering in the.
Mr.
This is a legislation that was passed not by a Liberal government, by the Parliament of Canada.
Thank you, Chair.
Mr. Saini, I've stopped your time, sir. I'm going to come to Mr. Ward's defense on this.
Thank you.
He was invited on behalf of the committee. His name was submitted because, as he said, he was an expert in tax havens. His testimony, whether you agree with it or not, was required or asked for by the committee, and so I don't think admonishing a witness is something, because he was invited by the committee, is something that I'm going to stand for, sir. So if you have questions with respect to what we're studying, I would invite you to go ahead, but admonishing a witness who was duly invited by this committee is not proper protocol. So.
At the same time, Mr. Chair, for a witness to go after the Prime Minister, which he has absolutely no knowledge, is not acceptable, and I will not accept that.
That's fine. So I'm going to ask you to continue, and I'm going to ask you to continue along the line of questioning, or you could give your time to Mr. Surrey. Mr. Surrey, you have 3 minutes and 45 seconds. I did stop the clock. Go ahead, sir.
Merci beaucoup, Monsieur le Président. Merci beaucoup.
Thank you, Chair. Thank you to the witness. You shared your expertise with us, and we would like to thank you for that. I don't want to put into question what you've said. I would like to thank you for the information that you shared with us. That said, for the benefit of those listening to us, I would like to come back to something that was asked in a previous question. When a public servant or a public office holder puts their assets into a blind trust, we know that there can be profits made. Would you agree with me in saying that there can also be losses to that person's assets?
Absolutely. In a blind trust, there could be profits and or losses made.
Mais vous avez bien dit blind, et puis...
You said blind trust, and I like that you use that terminology and the word blind. And how can we move forward? How could we have, and we're talking about a real conflict of interest, not apparent. And you mentioned we're talking about a conflict of interest, but we're talking about blind trusts. So what's your opinion on that?
Well, I think, I mean, just to use Brookfield as an example, if there are shares in Brookfield as an in a blind trust, does policies that benefit Brookfield, that encourage Brookfield, that reduce its tax liabilities and or increase its opportunities to make profits, there are still going to be benefits to that.
Merci beaucoup, parce que ce que vous avancez ici...
Thank you. What you're saying is quite interesting because we're talking about a hypothetical situation. So it's not a conflict of interest. It's an appearance of a conflict of interest, and the distinction is important. Canadians need to understand the language that we're using because we're talking about hypotheticals. You seem to be an important person, and so I want to understand how you could state that there's a correlation between tax evasion and a conflict of interest, because that's what I don't quite understand. We're in a committee, and our goal is to have transparency and the public's trust. We don't want to undermine that trust. And so the Prime Minister was chosen by Canadians. That said, I would like to come back to something that my father said, that we can't only look at ideas. I'm not talking about an appearance of a conflict of interest. I'm talking about tax avoidance and the matter of a conflict of interest. Is there a correlation? That's what I would like for you to speak to, because you are an expert in that field.
I think that aggressive tax avoidance undermines credibility in public institutions, and there is a correlation there that if a company or an individual can continually avoid its obligations to contribute back to the societies where profits have been generated, it does gravely undermine faith in public institutions, because as people making a living from labor.
Mais j'aimerais bien vous entendre.
But I would like for you, or I would like for us to be a bit more proactive, and I would like to ask you, what are the legal matters that we should focus on? Do you have anything to share? Because you did mention that you don't have a lot of knowledge on the Canadian system, but what should we change on a legal level?
Yeah, I'm going to need a very quick response, Mr. Ward, if you don't mind.
Absolutely. So, I mean, I think that the issue of blind trust needs a serious review, and I'll leave it at that.
Okay, thank you, Mr. Ward. I want to thank you for your testimony in front of the committee today, and appreciate you taking the time from Australia to share your experience and expertise with the committee.
Time is in Australia now.
Yeah, what time is it there, Mr. Ward? Somebody said it was like...
We're in the future. It's
7:30?
8:30 a.m. on Thursday.
8:30. Okay.
You are in the future right now.
Well, better than being 2:30 in the morning, Mr. Ward. So I want to thank you for your time, and I appreciate you appearing before the committee today. I have no other business. I do want to make a comment, though, that we have circulated a witness list. There was a work plan that was circulated among all members of the committee, and on that work list, there were names of witnesses that were here. If there was any objection to witnesses coming before this committee, there was a time and a place to do that. There wasn't, and so I appreciate, again, Mr. Ward, you being here today. That's it. No other business. Meeting's adjourned. Have a great weekend.
Okay. Wow, that was a lot more spicy than I thought it was going to be, but I knew this witness was going to be quite interesting, and based on having Cooper and Barrett come in here, it was really good. I'm just going to answer one of the questions here. I thought regular people couldn't refuse committee, only elected officials could say no. No, regular people, if they're asked to partake in a study, then they can say yes or no. If the person says no, then if it's the will of the committee, they can summon the person there and demand them to come. For example, when we had Randy Boissonneau and we had his business partner in, he refused twice, and then the committee passed a motion to actually force him to show up. But generally speaking, if like a witness like this, for example, where they're just an expert in their field and they're asked to show up, they can say yes, they can say no. You know, maybe they have other things to do, etc. And sometimes even if they do say yes, timing doesn't work out. And then as for Chris, that's what I thought. He's having to work extra and doesn't want to. He gets an extra stipend for this, though. Liberal MPs, Conservative MPs who are on a committee do get an extra stipend. I believe it's an extra $20,000 a year on top of their $200,000, and the chair gets, I think, $30,000. So they do get paid for this committee time, even though they're already paid a giant fat salary with benefits and pension and everything already. But they do get an extra stipend. So, we are going to call it here. We are live tomorrow at 11 a.m. We've got Gary, the public safety minister, in committee. So that'll be very interesting. And we've got question period at 2 p.m. And then we've also got OGO in the afternoon. So there'll be 3 live streams tomorrow. Should be pretty good. And yeah, I just want to thank everybody for tuning in. Thanks for watching. I did think this was going to go for 2 hours, but you know, it only being an hour, that's fine. We got what we wanted, and I will see you guys all tomorrow. Try and have a fantastic rest of your evening. And thanks for tuning in, guys. Cheers.